Hi, everybody. Good afternoon. My name is Andrew Meyer, and I'm joining you from Tovangar, the occupied ancestral lands of the Tongva peoples in what is now Los Angeles, California. I'm a settler PhD candidate in anthropology enrolled at the École des Hautes Études en Sciences Sociales, a social sciences institute in Paris, France. But I was born and raised on the stolen territories of the Ohlone peoples of Santa Cruz and in Oakland, California. I've been studying repatriation for 7 years in the private market, specifically on auction houses and dealers and fairs and auctions. Glad to be here.
Good afternoon. This is David Tarler. I have been in the National NAGPRA program, the National Park Service, since 2006. And prior to that, I was in the Archaeology and Ethnography program of the National Park Service. By training, I'm a Near Eastern archaeologist, and I have a law degree. I have been involved with trainings for the Department of Justice on cultural heritage law, beginning in 1993 through 2003. I have edited several compilations on cultural heritage protection. I'm very, very happy to take a walk down memory lane. I was the assistant editor for a journal called the Yearbook of Cultural Property Law, which we published for 5 years between 2006 and 2010. In 2000 and 2001, I was fortunate enough to work with the United States Sentencing Commission on a sentencing guideline for crimes, federal crimes involving cultural heritage resources, 2B 1.5. I look forward to speaking and hearing from you today.
Afternoon, everybody. My name is David Barland-Liles, or DBL for short, to not confuse me with my colleague, David Tarler. I'm calling you today from Northeast Iowa, within the exterior boundaries of a place now referred to as Effigy Mounds National Monument. I have a couple of roles with the federal government at the moment. I am the law enforcement program manager for Effigy Mounds National Monument. I happen to be right now the acting superintendent of Effigy Mounds National Monument. And I am also a part-time civil investigator for the National NAGPRA program. And Effigy Mounds National Monument is in Northeast Iowa, overlooking the Mississippi River, and I protect this place and manage this place in partnership with many, many nations, including the Iowa, the Sac and Fox, the Ponca, the Omaha, the Ho-Chunk, the Winnebago, and we work in a very kind of new and burgeoning trust relationship. I'm sure I'll tell you why the trust relationship at this place was so damaged by, indeed, the theft of cultural heritage by a member of the National Park Service. My previous role for the federal government prior to being the law enforcement program manager for Effigy Mounds was a special agent for the National Park Service. And I was the case agent that resolved a theft of indigenous human remains from the museum collection of Effigy Mounds National Monument to circumvent the provisions of NAGPRA. And it was indeed an act of racism. So I find myself here today seeing a circle close, or actually seeing the circle for the first time. And we recently returned those ancestors to their journey through the repatriation following the provisions of the Native American Graves Protection and Repatriation Act. It's my 25th year of law enforcement for the National Park Service. I've been with this agency since 1989, and recently, very recently, I accepted the first full-time civil investigator position for the National NAGPRA program. And I will begin that job in just a couple of days and strip myself of this uniform and be the nation's first full-time civil investigator for the National NAGPRA program. Thank you.
So I guess I'll get you started here, Colleen. For the study of the market, that's what I'm going to be talking about mostly today, not the legal or National Park Service issues that the Davids will be addressing. So as I said, I've been studying domestic and international markets for Native American ceremonial items for over 7 years. My dissertation focuses on both auction houses and dealers. On the one hand, I'm analyzing the ways in which they sell and justify the sale of known ceremonial items, while also paying attention to those who prefer voluntary repatriation instead of involuntary repatriation, in terms of the dealers and the collectors choose when they want to give something back instead of being forced to by a law such as NAGPRA or the upcoming STOP Act. And I'm also very much focusing on dealers and collectors and auction houses' resistance to the passing of the STOP Act. So I started studying this, the field of auction houses and dealers in Native American art in 2013 when I was in Paris for the controversial auctions of mostly Hopi sacred items and other Southwest tribes. And since then, I went to around 30 auctions in the US and in France, and around 20 fairs and shows where dealers sell Native American objects, some of them which can be considered art and others not. And so for a few years, I've been helping out the AAIA to track auctions, both foreign and domestically. And I've been helping to create auction alerts that are sent out to tribal representatives by the AAIA. So I'm focusing on most of the auctions that are happening in the US, but many happening abroad, such as in France, Germany, Holland, Belgium, England, Switzerland, Italy, Spain, Australia, and Canada. Most of them are happening in the US, but also in Canada and in France, which is the main European market. Although different Germanic-speaking countries are also into it. I also forgot Scotland and England sometimes, but they're usually pretty minority compared to African, Oceanic, and Asian objects in these so-called tribal art auctions. Whereas in the US, there are still many auction houses that really specialize or have specialized sales of specifically Native American art from North America and not pre-Columbian from South America or Central America, which is more popular in France. So I'm definitely not an expert, but I've developed a certain eye since I've been looking at tens of thousands of Native American objects online and in person for over 7 years. So kind of have an okay idea for an outside person. And although many tribes have been tracking their own items for many years, the AAIA is one of the only entities that really has a continental perspective in looking for indigenous heritage from North America. Meaning when I'm looking for items, I'm going from Greenland to all the way to Alaska, all the way down to the borderlands of Mexico, and including also Native Hawaiian items. So both within and out NAGPRA, and just not taking into consideration the colonial frontier, the barriers between Canada, Mexico, and whatnot. So for each auction I find, or that others find, I count both the total Native American items and Native Hawaiian items. And within that, the AAIA has come up with the term potentially sensitive items, which is a really broad term that casts a very wide net of any item that could have any sensitivity for a tribe, meaning is it ceremonial? Is it a funerary object? Was it stolen? Is it, in other ways, cultural patrimony important to the history or the identity of the nation? So potentially sensitive items in our counts don't include obvious works of art that were made for the tourist art markets, such as most Southwestern jewelry, except when we're thinking about potential funerary objects. Most contemporary pottery, but not all pottery, because there's a lot of excavated and other forms of sacred pottery, and most Navajo weavings or other specific things like that. So out of the tens of thousands of objects I've seen, we kind of split that up, but we let the tribes decide what is actually sensitive. I sometimes flag things that are obviously sensitive, that are well known to be ceremonial, or things that have been excavated and could potentially go against NAGPRA, ARPA, Antiquities Act, or stolen laws about theft. So the process of looking for items online, but I also do it in person at fairs and shows and in-person auctions. But yeah, most of these alerts are based on online databases and actual auction houses' websites. So there's no one centralized place to see all these auctions or to find all Native American and Native Hawaiian heritage for sale in the world. You kind of got to navigate many different specific auction houses that might not participate in databases. So you got to look on their specific calendars, or go back and forth between liveauctioneers.com, invaluable.com, bidsquare.com, highbid.com, interenchère.fr in France, auction.fr in France, Drew Online. So every week or two, got to just look through all these websites, type in all keywords into the search of the actual website of the auction house or in the databases, and use all different spellings for a specific tribe, such as Haudenosaunee, Iroquois, Inuit, Eskimo, potential misspellings of tribes, Hupa with double O, Hupa with HUPA, and for foreign websites, more general terms, because they know less what they're talking about, and that buyers don't really care as much about authenticity necessarily. But yeah, you use German words such as Indianer, Indianisch, French words such as Indien, and type in specific tribes, Hopi, Tlingit, Haida, North America, Amérique du Nord, and using those in both plural and singular form. So yeah, this is kind of just the process of looking for items. If I'm not already getting an alert, which any of you can sign up for on most auction house websites, to be alerted if any keyword is used. As I said, there's no centralized site for this. I would love for someone more tech savvy than me to develop an app where tribes can get notifications every time their keyword and cross all these databases and auction house websites, or somehow make the AAIA alerts easier to distribute for specific tribes. So let's get to some data that we've collected over these past few years. And it's since 2019, we've found way more auctions actually going on, both foreign and domestically. For example, there was, we found 63 foreign and domestic auctions in 2019, 190 of them in 2020, and we're already at 162 this year in 2021. So there's been different, there's been thousands of what we call potentially sensitive items. We've kind of tweaked what that means when we're counting up the data to see if we had 3,000 potentially sensitive items in 2019. Over 1,000 in 2020, because in 2019 we counted weavings, jewelry, and all Native American items found. So that's why the numbers changed a little bit there. And there's usually way more domestic auctions than foreign. But this year in 2021, we have 83 domestic auctions in the US, and we found already 79 foreign auctions, whether it be in France, Germany, Canada, Australia, Scotland, England. So 162 total auctions this year, and we found 7,000 potentially sensitive items, of which most of them, 6,000, are from US, and almost 400 are from foreign auctions. So that's only 7,000 potentially sensitive items, but we have over 20,000 items we've been through. So why have the sales gone up in terms of how many sales, and why more potentially sensitive items? Part of it is we've gotten better at finding sales online, both domestically and internationally. But there's also the possibility that, especially since COVID, there's been a lot more sales of sensitive items in particular, partly because auction houses may think tribal governments were too busy to monitor sales during the pandemic, partially because a lot of fairs, in-person auctions, and shows where dealers sell to collectors in person, and galleries, they've been closed because of COVID, so they had to move to online sales more. And collectors and dealers are getting older at all times, and most of them are older than 60, 70 years old, and their kids aren't interested. There's not that many young people interested in the older, more potentially sensitive items, Native heritage, as opposed to contemporary Native artworks. So they're trying to get rid of all their items now that the market's going away and they're getting old, and they got to get rid of them quick because they don't know what's going to happen. And also that's possibly the scare of the Stop Act. They're trying to sell them before the Stop Act is enacted, if it's ever enacted, that they're trying to export them or sell them before this law gets passed. And it's, some auction houses include provenance information about how they got it, and sometimes known dealers, some of them from Atata, have continued to export objects since they declared in their bylaws they're not selling known sacred items. But it's really hard to prove if it was acquired after NAGPRA in 1990 or exported after Atata changed its bylaws in 2017. So that's the main problem, is this burden of proof, that auction houses don't give much information about items. When tribes ask, they hardly answer. Either they play dumb, or they really are ignorant and have no idea what they're selling. They say it's a Hopi item from New Mexico, even though Hopi are from Arizona, or they'll say a Sioux item from Texas or something. You know, they just spell things wrong. They have no idea. But other people who know exactly what they're selling at the auctions, and by dealers, they play dumb, put it as little information as possible, and they don't tell tribes some auction houses actually mislead tribes, it seems intentionally, allegedly, from some tribal representatives who have experienced that. So they try to confuse tribes, they don't communicate. But some of them are, like Revere Auctions. Some auction houses are actually trying to get with the program. It's not, and to be respectful, it's not all of them, but most of them, out of maybe 1,000 auction houses in the world that are selling potentially sensitive Native objects. So going back to this burden of proof, the auction house, the dealer, or the collector is rarely forced to actually show provenance information and prove that an item is legally acquired, whether it's excavated on private land or federal or native lands, whether it was acquired after 1990. People at AIA and I also agree that NAGPRA should be applied, and it should be the dealer or the collector or the auction house to prove that it was acquired legally. And we'll see what the Davids and Colleen have to say about that. But let us move on. Thanks. I'll be happy to talk about so many other things if y'all want to.
Thank you, Andrew. And I was sharing some of the data as you were speaking, so I do hope that that came through good to the audience and you're able to see that. And right now, I'll turn it over to David Tarler. Oh, David, you're still on mute.
I apologize. Thank you, Colleen, and thank you, Andrew. I was asked to provide kind of a framework for the laws that protect cultural heritage, and then some of the laws themselves. And then I'd like to talk about NAGPRA civil penalties. And then if there is some time, perhaps read something that I wrote in the enforcement section for the Yearbook of Cultural Property Law in 2009 for the 2010 volume. So I'm going to go through this very quickly, but of course, since this is being recorded, you can refer to it any time. And let's start maybe with the Schoolhouse Rock version of the framework. So under the Constitution, Congress has what are called enumerated powers. Under Article 1, Section 8, Congress's powers include regulating interstate and international commerce and commerce with Indian tribes, as well as making all laws necessary and proper for executing its powers and all other powers vested by the Constitution in the government of the United States or any department or office of the government. Under Article 4, Section 3, Congress has the power to dispose of and make laws respecting the territory or other property of the United States. And under Article 6, the Constitution and the laws of the United States and all treaties made under the authority of the United States are the supreme law of the land. Now, the 10th Amendment to the Constitution reserves to the states and to the people the powers not delegated to the federal government by the Constitution or prohibited by the Constitution to the states. And that's it. So what about the extent of Congress's powers? Well, the extent of Congress's enumerated powers has been the subject of a long line of judicial holdings and doctrines. And based on them, Congress has legislated in the arena of matters affecting property generally and cultural heritage, including Native American cultural heritage specifically. I'm going to, and I would visualize the framework sort of as a kind of a pegboard with different size and different shape holes in it, which are the framework of the laws, which would be federal criminal laws, federal civil laws, tribal laws, state laws, laws that are that are regulated administratively, as opposed to in the courts, the common law, and the pegs are the various facts that would allow an action to protect or return cultural heritage to proceed. So very quickly now, I'm going to reel off some of the statutes that have actually been used to protect cultural heritage in the United States, starting with the Antiquities Act of 1906. Most of you are familiar with the power given to the President of the United States to declare national monuments, but the Antiquities Act also prohibited appropriation, excavation, injury, destruction of objects of antiquity situated on lands owned or controlled by the United States without permission of the secretaries of the department having jurisdiction over those lands. Today, the criminal provision is codified at Title 18 of the U.S. Code, Section 1866. The criminal violation of the Antiquities Act is what's known as a Class B misdemeanor. Our federal criminal laws are governed by a U.S. sentencing guideline manual. Today, the guidelines are advisory only and no longer mandatory. But the guidelines apply to Class A misdemeanors and felonies. So a violation of the Antiquities Act falls outside of the guidelines manual. And a court may impose a sentence authorized by the Act, which is a maximum of 90 days incarceration or up to $5,000 fine. Now, there's a split of authority among the United States Courts of Appeal on the constitutionality of the Antiquities Act. Very bad facts made a very bad decision in the United States Court of Appeals for the Ninth Circuit in 1974 that the criminal provision of the Antiquities Act was unconstitutionally vague, and that decision affected 9 of the states that fall within the Ninth Circuit. The 10th Circuit disagreed with the Ninth Circuit and simply resorted to the dictionary meaning of the words object of antiquity in upholding a conviction under the Antiquities Act. And so the Antiquities Act is not dead. In fact, it has been used as a prosecutorial tool outside of the Ninth Circuit, and has also been used cultural heritage resources. And so fortunately, in the rest of the circuits, the Antiquities Act is still good law. Another statute, of course, is the Archaeological Resources Protection Act of 1979. And there are several components to it. There is the unlawful excavation or damage to archaeological resources, which are the material remains of past life or activity at least 100 years old, and removed illicitly from public lands or Indian lands, the sale, purchase, or transport or receipt offer of sale, either in violation of that particular prohibition or any other prohibition, is also a violation of the of ARPA. And the interstate or international trafficking in archaeological resources in violation of state or local law from any location is yet another violation, criminal violation of ARPA. Anyone who acts or counsels, procures, solicits, or employs another to violate that statute may be convicted of a criminal violation of ARPA. ARPA also provides for civil penalties. Those are done administratively. When we talk about criminal law, we know that there are two aspects to a crime: the violation conduct and the intent of the perpetrator. And those two components are required in order to convict a defendant of violation of a crime. Under the civil penalty provisions of ARPA, a violation is a strict liability offense, so no intent is required. And there are advantages to using the civil penalty provisions. First off, a civil violation is a strict liability offense. Second, acts that are committed negligently or inadvertently can be pursued through the civil penalty process. The actual damages can be recovered. The process has certain efficiencies over criminal prosecution, both in time and resources in making the case. And the disposition of the ARPA civil penalty process is within the purview of the federal land manager and not the Department of Justice. There has been some law in the Ninth Circuit again with respect to the intent provision of ARPA. ARPA is a general intent crime, which means that the perpetrator needs to have knowledge that the acts that the perpetrator is committing are acts that are considered to be illicit or wrongful. There is not a specific intent required, just that particular knowledge. And yet, in a case called the U.S. v. Lynch, again in the Ninth Circuit, the United States Court of Appeals determined that the defendant would have to have been shown to know that the item that was involved in the offense conduct was an archaeological resource. And so despite the fact that the perpetrator went on land that did not belong to him, it was Forest Service land, looked for things to take, looked for old things, as he admitted, excavated a Native American skeleton, took the skull, transported it home, had no permission to do that. The court found that he could not be convicted unless he knew that the object itself, in this case, actually the human remains themselves, were at least 100 years old. And so to date, that is the only United States Court of Appeals that has decided the issue of intent with respect to knowledge about the object or the human remains being archaeological resources. Another statute that comes up is theft of property belonging to an Indian tribal organization and unlawful receipt of property stolen from an Indian tribal organization, and that is 18 USC section 1163. Just to go back to ARPA for a second, that statute's codified at Title 16 of the United States Code, 470 AA through MM, and under ARPA, forfeiture is available, and any forfeitures or penalties that are collected through a prosecution or through a civil penalty under ARPA, if they have been removed from Indian lands, go to the Indian tribe. Also, the ARPA regulations make clear that any archaeological resources removed from Indian lands belong to the Indian tribe. So theft of property belong to an Indian tribal organization, 18 USC 1163. This is a theft of property statute, property belonging to an Indian tribal organization or in the custody of a tribal organization official. And the second paragraph concerns unlawful receipt or possession of that property. Statute defines Indian tribal organization as any tribe, band, or community of Indians that is subject to the laws of the United States relating to Indian affairs, or any corporation or other group that is organized under any such laws. And so the definition there is much broader than, say, under NAGPRA. Another statute, of course, is the criminal provision of NAGPRA at 18 USC 1170. 1170A deals with the use for profit of Native American human remains, and that without the right of possession. That means location is not part of the offense. B deals with the use for profit of any other cultural item under NAGPRA. A first violation of NAGPRA is a misdemeanor. Second or subsequent violation of this criminal provision is a felony. And because the word knowingly is in this statute as well, it too is a general intent crime. Another statute is the theft of major artwork statute. That's a Title 18 USC 668. It's the act, and here the definition of museum is different than it is under NAGPRA. It's the act of obtaining by theft or fraud an object of cultural heritage, or receiving, concealing, exhibiting, or disposing of such an object, knowing that the object has been stolen or obtained by fraud. An object of cultural heritage under the statute is an object that either is over 100 years old and worth in excess of $5,000, or of any age and worth at least $100,000. And a museum is defined in that statute as an organized and permanent institution situated in the United States whose activities affect interstate or foreign commerce and whose essential purpose is educational or aesthetic, has a professional staff, and owns, utilizes, and cares for tangible objects that are exhibited to the public on a regular schedule. Theft of major artwork, again, is a general intent crime. And this statute has been used with respect to theft from tribal museums. National Stolen Property Act, which has two parts to it: the interstate transportation of stolen property and the sale or receipt of stolen property, which is across the state or United States boundary. The interstate transportation provision is at 18 U.S.C. 2314. The sale or receipt is at 18 U.S.C. 2315. Again, this is the government needs to prove that the defendant knew that the goods had been stolen or obtained by fraud or transported, bartered, sold, etc., the property knowing that the goods had been stolen. Mail fraud has been used with respect to prosecutions involving cultural heritage, and wire fraud as well. The mail fraud statute is at 18 U.S.C. section 1341, and the wire fraud statute is at 18 U.S.C. 1343. Injury to government property, 18 U.S.C. 1361. That's a specific intent crime. Value is not defined here, although it is defined in another theft statute, which is very interesting, especially as the theft and embezzlement of government property statute at 18 U.S.C. 641 does have a definition of value, which means face, par, or market value or cost price, either wholesale or retail, whichever is greater. That distinction was very important in a case where the United States couldn't find an equivalent commercial value for a petroglyph that had been stolen and damaged, and instead wanted to use archaeological value, the cost of obtaining information related to the object, because it had gotten a value for an object that did not track exactly the petroglyph value, because you don't find petroglyphs very often for sale, unless, Andrew, you want to correct me. And the court determined the United States had that value. It was a commercial value. It didn't use it, and therefore the two defendants were acquitted because the United States had not proved its case beyond a reasonable doubt.
David,
Yes.
this is Colleen. I think
Sure.
that I was wondering if I'm sorry to interject, if you might be
Sure.
able to talk about your work with the Cultural Property Journal. If you could give the audience maybe a brief description of that, I think they might find that really interesting.
Sure. Well, this journal was published for 5 years between 2006 and 2010, and it had various sections to it. One was a federal enforcement section, which I wrote, that reviewed all the cases, most of which were unpublished decisions that had involved cultural property or cultural heritage during the previous year. And then there were sections on the art market, international trafficking, underwater cultural heritage, Native American cultural heritage, and then there were various articles as well that accompanied the yearbook. Sherry Hutt, the former manager of the National NAGPRA program, was the editor, and I served as assistant editor to her. So some of these statutes were actually used in order to prosecute crimes involving cultural heritage during the time that I was writing the section in the yearbook. Those are federal criminal statutes. Again, some of them have civil administrative aspects to them, such as ARPA civil penalties. Of course, in addition, there are state laws that protect cultural heritage. There are tribal laws that protect cultural heritage, including tribal codes. Just to name a few, in compliance code, the Navajo have compliance codes. Enforcement codes exist for the Coeur d'Alene, the Wallapai, the Navajo, Sault River Pima Maricopa Indian Community, the White Mountain Apache, and the Yakama Nation Confederated Tribes and Bands. And so those codes are also available. So we have this amalgam here of federal criminal law, we have civil law, we have administrative law, state law, tribal law, and we also have the common law. Actions to recover property that was either that was never abandoned, but rather was either lost or mislaid. Those actions are available as well. The other thing I wanted to talk about were the NAGPRA civil penalties. You've already had excellent tutorials with Melanie O'Brien, the manager of the National NAGPRA program, on the goals of NAGPRA and on the various compliance requirements of NAGPRA. NAGPRA has a section 10.12 in the current regulations on civil penalties. Those are authorized under the statute currently, and we will discuss the draft proposed regulations that have been that you all have seen. But currently, there are 9 ways that a museum might fail to comply with the requirements of NAGPRA. These the civil penalty provisions only apply to museums, not federal agencies. Federal agencies are subject to challenge under the Administrative Procedure Act. These civil penalties under NAGPRA are administrative. The secretary has delegated authority to assess civil penalties to the Assistant Secretary of the Interior for Fish and Wildlife and Parks. And the current 9 ways that a museum might fail to comply with the requirements of NAGPRA include not completing a summary, not completing an inventory, not consulting as required, not repatriating without publication of a notice in the Federal Register, not informing recipients of repatriations of any known toxic treatment of any of the objects being repatriated, and not offering to transfer control of culturally unidentifiable human remains upon request by a geographically affiliated Indian tribe or Native Hawaiian organization, as well as refusal to repatriate as required. The issues that arise in investigating NAGPRA civil penalties are sometimes all the time factual. Sometimes they're legal as well. As I said, only a museum may be assessed a civil penalty, and the question arises often as to whether the institution is actually a museum under NAGPRA. One legal question that arose with respect to an investigation involved whether certain funds that an institution received were actually federal aid in the form of funds from a federal agency. The funds that were alleged to have been received by this institution, which was not an institution of higher learning, was not a state or local government, and were received indirectly from a state, involved payment in lieu of taxes from the Department of the Interior to the state government, which then distributed those monies, and the institution received some of those funds. So the question was whether those funds that were received indirectly by the institution through the Department of the Interior as payment in lieu of taxes, or PILT funds, constituted aid in the form of federal funds. The research showed that the courts have held that those funds were compensatory and were not federal financial assistance. So those funds could not be shown to be federal funds sufficient to show that the institution receives federal funds. Another case involved an allegation that a museum, an institution that did receive federal funds, had failed to complete a summary. And in order to determine whether it had actually failed, it was necessary to determine whether the institution had control of any NAGPRA cultural items. And so the investigation centered on a traditional religious leader who provided an affidavit to show that an item under the control of this institution that received federal funds was actually a sacred object and perhaps an object of cultural patrimony. And that was necessary because when there is a civil penalty, the department needs to be ready to go before an administrative law judge and prove its case by a preponderance of the evidence. And so sometimes there are factual issues and sometimes there are legal issues in investigating these matters. One other thing, I've been talking about criminal law. I've been talking about proof. A NAGPRA civil penalty, like an ARPA civil penalty, is a strict liability violation. It doesn't require proof of intent. But any litigation or prosecution is a very expensive proposition. And to the extent that we can pursue the goal of compliance and ultimately repatriation, as Melanie has told us many times during this collaborative manner. And so we should, the National NAGPRA program is constantly providing technical assistance to museums, Indian tribes, Native Hawaiian organizations, potential lineal descendants, on working together by explaining what the statute requires, and hopefully that will lead not to litigation or an adversarial relationship, but towards collaboration on working towards the goal of repatriation. Maybe we can do a poll, Colleen, just to see what experience tribes, NHOs, and museums have in working with the National NAGPRA program on issues that involve compliance and where there might be some disagreements.
Yeah, sure. I just want to let the audience know the poll is published. And while we're waiting for results, maybe we can move over to David Barland-Liles and we can hear from him in the interest of time.
Great, thank you.
You bet. Thank you, Colleen. Yeah, I'll blast through, hopefully, my contribution to this panel. When it comes to investigation and enforcement, especially in the federal system, I think the area of most concern to me, and reward me for my candor here, is in the area of innovation. When I've been a federal law enforcement officer for 25 years, the amount of colleagues that I've run across in the 3 federal academies that I've gone through and the many agencies that I've worked through on many cases that are actually interested in this line of work, this field of law, is frankly pretty darn low. And so what I would like to see more as a federal officer is a more comprehensive approach to this area of law, this area of enforcement, and this area of investigation. Case in point is Effigy Mounds National Monument. As a special agent for the National Park Service, I was a general special agent. Whatever felony or complex misdemeanor that happened within the exterior boundaries of the national park system that got assigned to me is what I investigated. When I came to be aware that Effigy Mounds National Monument in 2011 was beginning to become concerned that human remains were missing from the museum collection, and nobody knew why, and nobody had done anything about it in the past. And they called me to look into it. That was really how I started to be involved in investigations associated with the field that NAGPRA sits in. And I remember going to a consultation between the superintendent of Effigy Mounds National Monument and the partners that affiliate themselves with the land we now refer to as Effigy Mounds National Monument. And they were passing around what turned out to be a fraudulent document. I happen to have a copy sitting here right on my desk because I'm in Effigy Mounds National Monument. And this flimsy fraudulent document, which is a report of survey, sustained a conspiracy and a criminal enterprise for 21 years. And they passed it around the table to the tribal partners that were there. And then it got to me, and I read something on it, a report of survey about what the federal government, in this case, the Effigy Mounds National Monument, was intending to do with property that it accesses or X is trying to access. And it states in the justification section, miscellaneous material that does not fit the scope of collection statement for artifact museum storage at Effigy Mounds National Monument. Unfortunately, what they're referring to here is the human remains of 41 ancestors. And this document was dated July 16th, 1990. So innovation began to contribute to what was clearly a opening of a criminal investigation in a time of crisis. It was 2011, and we were discovering that human remains were missing from the museum collection of Effigy Mounds ancestors, and they were stolen or likely stolen in July 16, 1990. And I used a federal rule of criminal procedure. It's called Rule 6. And embedded in that rule is the opportunity, should it benefit prosecution, to share what's called grand jury material, secret federal criminal investigation material with specifically Indian tribes, should it benefit prosecution. And at that moment, I decided that all the information that I find as the investigator at the launch of this investigation, I will share with the tribes that affiliate with themselves with the land we now refer to as Effigy Mounds National Monument. I didn't know at the time, though, that had never been done before. So at least we've not found another example of it. What that amounted to is the 20 or so nations that affiliate with Effigy Mounds selected 4 tribal historic preservation officers who acted as, in lieu of no other term, they were what we call tribal monitors of a federal criminal investigation. And they represented all those nations, and they had direct access to all my evidentiary findings, all the facts that I found as a criminal investigator throughout the entire course of that investigation. And indeed, at times joined me as an investigative partner. One of the concerns that emerged in that investigation was the realization that the National Park Service had allowed this crime to occur for 21 years. And so what happened was the superintendent of Effigy Mounds National Monument, his name was Thomas Munson, from 1971 to 1994, he was the superintendent here, saw the pending approach of the human rights law, the Native American Graves Protection and Repatriation Act approaching, and he decided to try to circumvent that law to hold on to and prevent repatriation, but specifically hold on to funerary objects associated with people that were excavated from mounds at Effigy Mounds National Monument in the 50s and 60s. So he stole the human remains of all 41 of those people and used this fraudulent document to hide that. And he imprisoned them in his garage for 21 years. The National Park Service, especially around 1994, 1995, when we needed to be completing our inventories to meet the provisions of NAGPRA, began to become aware that human remains were missing from the collection of Effigy Mounds National Monument, one of their units, and they obfuscated it. They indeed covered it up. tribal partners stood right next to me in an archive, finding that very information, the facts that supported that. And of course, it was very important to me as an investigator to understand why a crime was allowed to perpetuate for so long, because it indeed weakens prosecution. If a superintendent steals human remains and then the agency doesn't do anything about it for 21 years, that weakens prosecution to some degree or another. And we're going to have to figure out what to do about that. A couple other innovative things we did during that criminal investigation. I'm sorry I'm talking so fast, but I just want to get through this so we can have quick Q&A. Is the U.S. Attorney's Office accepted this case right away. I presented it as the case agent. They said, yes, we want to prosecute this matter. And then I informed them that 20 sovereign nations know everything that I know. And by the way, not a single leak happened with those 20 sovereign nations that knew everything I knew. It was absolutely 100% a relationship of trust and empowerment, mutual empowerment. So the U.S. Attorney's Office said, well, how'd you do that? I said, I applied Rule 6 of the Federal Rules of Criminal Procedure, and, let's go. And they began to enter into consultation, government-to-government consultation with all of these nations to determine what's the best way to prosecute Thomas Munson for what he did. And it was a really fascinating process. The U.S. Attorney's Office had never entered into government-to-government consultation with sovereign nations. And there was a really steep learning curve, but it was also a really kind of beautiful process as well. And they finally reached a point where they fully accepted that this is actually empowering, which is not what they're used to. They're used to, when you share information, they think that weakens them generally. But in this particular matter, as that trust built between government and governments, and we realized that we're entering into a process of mutual empowerment that was exponentially increasing our odds of having a successful resolution in this criminal matter. It's a relationship of trust, and it just kept on building and building to the point where even if Munson were to not want to go to trial on this, I should mention that I found the human remains in his garage, by the way. So I caught him, right? If he doesn't want to go to trial on this, and we need to, and we can enter into a plea agreement, what would that plea agreement look like? And what would we charge him with? So it was our partners that came up with the determination of what this plea agreement will look like and what is the appropriate charge to charge him with. And initially they were like, well, if this was our judicial system, we would take Thomas Munson, we would cut him up into many, many pieces, and we would spread him out as far as we can. And his journey on this earth will end today. We recognize we can't do that. We are in your criminal justice system. Therefore, we want various things. We want him to go to prison. We want him to pay for repatriation. We want him to pay a fine. We want him to apologize. We want him to clean toilets, do community service, something. Yes, we can meet all of those. And by the way, since he treated our people like property through this report of survey fraudulent document, we think we want him to go to prison for theft of government property. We want to poke him in the eye. If that's the way you're going to treat us, put us in garbage bags, cardboard boxes, hide us in your garage, and prison us, you're going to go to prison for that. So a lot of innovation. We have everything David Tarler spoke to us about. There's a tremendous amount of room for innovation here. I should also say that all 20 sovereign nations were determined to be considered victims of one person's crime, Munson's crime, and they showed up at sentencing and spoke to the impact of his crime on them and their nations. I should also mention, though, when it comes to institutional will, the National Park Service is very shamed by this, so much so that not a single senior leader of the National Park Service showed up to the sentencing of their superintendent who did this racist act to circumvent this human rights law. So it was really just me and, a couple of lowly, just field employees. So, I try to change every day the institutional will of my agency. To that matter, obviously we're seeing it, some growth in capacity by the National NAGPRA program. They have created a new position that never existed before, a full-time investigator position. And one of the major components of my job as a civil investigator for NAGPRA is to integrate and intertwine with other federal investigative entities. Many allegations that come to the National NAGPRA program for violations of that human rights law have criminal components that could be intertwined in that. And already on some of the investigations that I have done for the National NAGPRA program, since I'm a civil investigator for NAGPRA, that those criminal components that could be there need to be addressed by criminal investigative components. And I turn to often the art crime team of the FBI, and I hope to continue to be a force multiplier and subject matter expert to assist them with these. And I hope that, to Andrew's point before, that we have a stronger, more comprehensive approach that includes more subject matter expertise, more really authentic investigators and enforcement officers that are actually interested in this realm of law. And I hope that helps feed even the art crime team that to address these types of criminal enterprises that are impacting so many nations so horribly as we continue to perpetuate these terrible crimes and that my ancestors have been doing forever. So I realize we're at the 45-minute mark. I just want to stop there to give us some time for question and answer.
Thank you, David. I want to show this comment on stage really quick. Oh, I thought it was going to go really big on the screen, but Melanie was simply sharing the Federal Register link to note that those same Indian tribes were also identified as being culturally affiliated to the human remains that were stolen. Just to add to that.
Yeah, I should also mention that all those ancestors have been returned to their journey here at Effigy Mounds National Monument.
That's incredible. Thank you for sharing that. I was actually wondering the outcome and was planning to ask. Thank you. So we do have quite a few questions. So let's dive into them. And I'll show them on stage. Well, first of all, I'll pin you all there. And I'll show them on stage. So Andrew, do you or the association help identify culturally sensitive items from individuals looking to return to their people? I might be able to help with this one too.
Yeah, you're way more versed in that. Colleen, I'm definitely, as I said, definitely not an expert. And nobody's approached me in the dealer collector world per se. Even though I have interviewed dealers and told them you should return this treaty to the Fort Berthold tribes, for example, or have you thought about donating this to a tribal museum? So I kind of talked to people who didn't ask for it, dealers and auction houses, but no, that's only family members and like other friends are like, oh, you work in Indian art. Can you tell me what this is? Should I give it back? And often it's really depends. I've kind of facilitated actual ancestral remains going back from some family friends, and I helped them get in contact with the tribe, and still dealing with that, trying to get them to rest. And other people where it's just Dene Navajo earrings, and that's really sweet of you to want to give it back. You can contact the tribe, but they probably don't have time for some earrings that your grandma has in Australia. But it's really sweet of you. And other people, is this a yokits or a miwok basket? And so I give them information to contact those people if they want to. But yeah, Colleen, you're way more involved in that side of things.
Well, thanks, Andrew. And honestly, it's not uncommon for the association to be contacted about similar situations. We get contacted quite frequently about individuals who, for whatever reason, have items in their possession. And a lot of times they don't know much about the items, and it's not the association's job for us to determine if something is an item of concern or a sensitive item. What we mostly do is try to find out as much information about the item as we can. Specifically, location is the best, and that way we can determine which tribe or tribes to reach out to, and we'll just simply connect tribal representatives and leaders with those individuals to let the tribe sort out if they'd like to proceed with having that item returned to them or not. So we do our due diligence to connect individuals with the tribe or tribes in the area that the items were removed from, to the best of our ability anyway. Okay, so next question, let's see. What can we do to educate auction houses about these issues? That said, many exchanges, in quotations, of cultural items are now moving, also quotations, underground. So you won't find out about them on social media or the internet.
So, yeah, I don't know if I mentioned that in the presentation, and this links to another question from Sarah Glass, who said, are auctions or fairs the only source of sales you track? Are there other types of sales you found during your research? Can you put that big other question back on the screen? So yeah, to educate the auction houses about the educating actually makes them go underground sometimes, as we've seen in Paris, and what the auctioneer Alain Leroy in Paris from Eve Auction House has told me several times. When I still go to periodic Eve auctions in Paris, he's saying, it's because of you guys that protested that these things are going underground. It's kind of your fault. It was public and now it's private. So those kinds of auction houses, you can't really get to them. You can't educate them. They'll use it against you. But as Shannon said, there's only one auction houses, Revere, that is actually trying to consult with tribes before putting things on sale. I'm just trying to not get sued for libel, saying a lot of auction houses, but most of them are allegedly doing this completely without any care for the law or tribes, allegedly. But yeah, to educate them, it's really hard because they're not willing to learn unless they use it for commercial value. If they get more information from the tribes, they might say, well, this is really sacred. The tribes try to get it back, especially in underground, non-public spheres where it's at a gallery or at a show, a fair, on eBay. That's going to Sarah's question. There's all sorts of online forums, where even Facebook these days, where native art and stuff is being sold. So yeah, not many people are willing to learn. Hopefully some of the younger people in auction houses are getting with the program, not to be ageist, but there's a lot of younger white people that are unreasonable as well. So we're just hoping with the new generation that there'll be more people that are willing to be more respectful and not just feeling attacked all the time, like you're killing the market by trying to get your stuff back, but rather work with tribes. And I have hope that not just Revere Auction House will do that.
Do you want to answer that next one too, Andrew?
Yeah, as I said, yeah, mostly the auctions are the only real one that is data-wise to easily track and keep data, as opposed to eBay, which is really random sellers at random times, and it's maybe a couple objects here and there. And at fairs, it's really hard to do have systematic data or tracking when. So if I see something that's obviously a ceremonial object, you can't do real data like how many sacred or potentially sensitive objects are being sold at a fair. When I can't go to all of them, you have to be on site. You have to send travel reps to Santa Fe, Albuquerque, Los Angeles, San Francisco, New York for the antique shows to really be on the ground. And there's so many other artifact fairs in St. Louis, out in the middle of Iowa, Florida, and Texas. So we can't be at them all. And I'm sure there's human remains being sold, because I found a couple, at least what they call human remains, for sale in auctions. Usually they're animals or other non-human relatives. But yeah, we can't track it all. Some of it's still very localized and hard for us to access. So we can't do it all. We need more people tracking more of this stuff, more people that have a intertribal perspective in the market, in contact with tribes.
Miigwech, thank you. This one might be geared towards the Davids. Most land in the U.S. is not public or tribally owned, and most cultural items are taken in exchange from these lands. Should we rely upon state and local rather than federal statutes to protect and repatriate these items?
Well, some of the statutes that I've referenced involve interstate or international trafficking in cultural heritage. And so a crime that might otherwise be a state or local law violation becomes federalized. But yes, it is important that state laws be enforced, and almost every state has a law saying that it is illegal to traffic in stolen property. It's not just the federal government. So I think it's very important to identify those state laws, because some of them actually are important in enforcing federal laws, such as the interstate or international trafficking in archaeological resources in violation of state or local law. It's also important to work with states, especially when we're talking about NAGPRA, because when there is a crime and there is a forfeiture to the state is a museum for purposes of NAGPRA, because it receives federal funds, and now it has to comply with the requirements of the Act. And also, it is eligible to receive a NAGPRA grant for carrying out that work too.
Thank you. Next question from Mr. Robert Hershey. Could you please speak to the value of the Lacey Act?
Well, Lacey Act violations are natural resource violations. There are federal statutes that certainly could be implicated. The Bald and Golden Eagle Protection Act was used to forfeit a headdress worn by Geronimo at the last powwow some years ago. And under that statute, the headdress was forfeited to the Fish and Wildlife Service, who was required to comply with the requirements of NAGPRA with respect to the headdress. So yes, natural resource protection laws could certainly be implicated in protecting cultural heritage.
Thank you. And we have another question from Timothy McEwen, who's also a member of the National NAGPRA Review Committee. And his question is to Andrew. Recent public French auctions seem to indicate that the pipeline of recent acquisitions from the Southwest has been somewhat disrupted. Does your information on underground French sales support that?
Thanks, Mr. McKeon. You've been a great inspiration over the years. And so it's really hard to tell when these items were being imported or exported out of the States into France, especially in 2013 when there was hundreds of Hopi friends and other mostly Southwestern sacred items for sale. And so that's the pipeline we're talking about, exporting from the US to France. And a lot of those were actually in France for a long time before going up for auction. Others came more recently, just before the auction. Some were consigned directly, like with the case of Acma Shield, by an American dealer, and sent to France before being put on for sale, and then sent back to him eventually. So it's hard to know this actual pipeline. It doesn't seem disrupted. They seem to be being more careful, because there are some French dealers and collectors that come from Paris to the fairs in Santa Fe, not since COVID as much, and they come to auctions and whatnot, especially in the summer. And they might be able to acquire in an underground setting items that wouldn't be publicly at the galleries or at the fairs or on auction. So that could be one of the pipelines. The real thing is that there's a lot less being sold in France. Like most Hopi friends seem to be obviously fake. It's often made by Polish people who want to make money off of that. So the sales have definitely gone down. They haven't been as bold. I know as Ms. Knowles said that it's definitely condescending when Alain Leroy said, "It's your fault the sales are going underground," because we're objecting to these sales. It partially is maybe they've run out of stuff to sell, or run out of these very high profile sensitive items. They've gone underground, because I've seen a lot of them at the flea market in Paris, a lot of them fake. The flea market is much less regulated than auctions or galleries, even though galleries in Paris, there's not many people coming to check. And in any case, it's really hard to prosecute them in France, so they can kind of sell whatever they want, unless I come in or a Hopi guy studying abroad or on vacation in Paris might randomly see one day. But yeah, most of the time it's hard to regulate in France. But to answer your question more directly, Timothy, it has not been disrupted. It's gone down, it's decreased, and it's hard to know exactly the reasons for that.
Thank you, Andrew. Well, that is all the questions we have, and we are at the end of this session. Does anyone have any final thoughts that you wanted to share with the audience before we wrap up? I'd just like to say thank you to all three of you. This has been a wonderful session and so informative and really exciting to share the work on auctions that Andrew does and what the association does through our action alerts. And so thank you to all three of you. And to the audience, please remember to take the polls. And I do see we have a raised hand. So I'm going to acknowledge it really quick and hand over the mic to JD. JD, are you there?
Yes.
All right, it's all you.
And one thing I wanted to mention was the Goodwills, and I don't see a video, but you'd even mentioned the petroglyphs. And particularly, Andrew, when you mentioned the idea of these younger kids getting rid of their collection, their family's collections, I actually have in my hand a petroglyph that was, you can see it's been removed, and this was at a Goodwill. I also have a couple other items, and I know we're talking about culturally sensitive items, but I think that's an area that I think we're missing, and I don't expect anybody to actually, try to get people that can go find these areas out. But I think what's happening too is when the younger generation sees this stuff there, they realize they can't sell it, they get rid of it. Now, once I was in the Goodwill and I was talking to the person that this was an entire collection, the actual manager was saying, well, no, I want to go through everything first. Because I said, now, is there a way that we can go through this? Is there something we can do? I mean, you have an entire collection here. And she said, no, I'll go through it first, and then we'll put out piece by piece. And she said, we don't know what days we're going to do it because the value will increase. And this is in Longmont, Colorado. And I think that may be something that we want to be aware of, because we don't know what else is getting by. And I wished I did have a video. The video was working, because then you can see the items, because I do understand we're talking culturally sensitive items, but who is to determine what is, particularly people that are in there, and who knows what these people actually have. And I've seen this time and time again. I've actually gone through and I've seen baskets that shouldn't have been just placed with the baskets that need to be thrown away. I just thought I would bring that up. And thank you for what you do. I didn't even realize this was there. And now I realize I actually have a way to go. Oh, and the last thing I wanted to mention real quick is somebody actually shared with me the federally funding for the Goodwills that was on the video before we did this. And because they're federally funded, I was curious to know if maybe we can get, or you can get them to voluntarily, when somebody gives up this entire collection to the Goodwill, maybe they can voluntarily call somebody up and say, hey, can you come and evaluate these? And I'm going to call them treasures, or these sensitive items, or whatever you want to call them, because, these things are priceless, in terms, I'm sorry, I'm getting emotional, but, if there's some way we can actually include the Goodwills. And again, thank you for what you all do.
Thank you, JD.
Real quick, in these 7 years I've been in this realm, I've had to kind of learn how to think like a dealer or a collector. And hopefully law enforcement will be trained in this way, and customs agents, when Stop Act is passed, to have more knowledge. I'm definitely not cut out to be a law enforcement person, but hopefully they can learn this, how it works, the trade in the art market and whatnot. But yeah, got to go to garage sales, Goodwill, flea markets, estate sales, random old rich people selling their houses with everything inside. You never know where any of this stuff can be. And so, yeah, it's endless. And we, got to have more people trained to look for that sort of stuff. And yeah, in terms of petroglyphs, I've seen some of them taken off of sites. That one of the only repatriations that worked from France was to Mexico, but not to the specific indigenous descendants of the pre-Columbian, pre-contact architectural item that was part of a building at an archaeological site in Mexico. And through the bilateral treaty between Mexico and France under UNESCO, they were able to get back this piece because they knew it was specifically linked to this archaeological site belonging to the Republic of Mexico. And so that'd be great once the Stop Act is established and there's a certification process and a treaty can be signed between US and France. They can add that sort of thing. If we know an actual object such as that's from Mesa Verde or from Chaco Canyon, maybe it's not architectural, maybe it's not a petroglyph, but if it's a pot excavated from Mesa Verde, that's kind of government property. So hopefully we'll get that.
Thank you.
Everything back.